Now the slide is visible to you, I hope. Am I audible?
Yes, sir.
Okay, great. So we can start. So basically today the lecture all about intellectual property. Before going into the deep part from classroom to startups and creators, I would like to give you a basics about what IPR is and how IPR is there in the picture and like what we can learn through IPR. That is a major part which we are going to see today. IPR, before giving introduction to IPR or what IPR is, I just want you to think, before we dive into intellectual property, let me ask you an interesting question. Imagine if the first iPhone design could be copied freely without any legal consequences. Would Apple have invested billions of money in it? Obviously, it is a thinking point. Like, would how would they usually do it when a billion of money is there in this particular part? So being coming to intellectual property, I just want to start it with a small example. For example, we know what property means, but now when coming to intellectual thing as a part, so ultimately a thing generated through your intellect is intellectual property. For example, there are multiple types of intellectual property which we are about to see, and there are multiple types of things which are there into intellectual property, and what are the schemes which are there under intellectual property that we are going to see in the later part. So this is just an activity. Like before getting into IPR lectures or taking into IPR lecture, I do basically follow this activity as a part. So for now, you cannot draw the biscuit. So for example, just you imagine that if someone told you to draw a biscuit and name that biscuit, what name would you suggest? Or what kind of biscuit would you have drawn? We need some answers now. So can anyone answer stating like, if I could have told you to draw a biscuit or name a biscuit, what biscuit you would have drawn? Looks like I will call the biscuit Saltel. Okay. What about others? I feel like we have 65 participants over here. There might be some review from the other participants. If I tell you to draw a biscuit, like what kind of biscuit would you draw? Or like you would give a name to a biscuit. Okay, I'll move ahead. While doing this activity, while I have done this activity in, I will draw a star-shaped biscuit. Okay. While doing this activity in the particular class or through the particular other sessions when I have done this activity as a part, star-shaped biscuit with the name Starlight. Okay. So while doing this activity with the class of 100 students or 150 students, I usually came to approach where people usually draw a biscuit in in Mumbai as a part. People usually draw a biscuit of Parle-G as a part because name of biscuit health choice. Okay, so there are multiple types of biscuit over Mumbai. When I tried this activity to multiple parts, so I usually found a thing that people usually draw a Parle-G biscuit because the Parle-G biscuit has captured their mind till now. Ultimately, whenever someone says Parle-G, you already recognize that it is a biscuit brand which is going to be there. And when I tell them to draw a flower, I cannot find a similar answer in everyone's particular mind. But when I tell them to draw a biscuit, their mind has already selected some biscuit as a part, and they tell that particular name. So over here, how your intellectual is built, and like you just know that brand only. There are multiple brands, but there are certain brands which are fixed under your mind, which you usually see. So why I chose to bring IPR as a part? So IPR is having a huge history. IPR is not just limited, and IPR is having a huge scope as a part. So now getting into history of IPR. So how in ancient India IPR used to work. So there were no formal laws before. There was no protection norm. So usually we had IP from a long time, but there was no protection ultimately there. Then British era came into picture where they started getting protection for glasses and potteries which they used to prepare. So in 1856 and patent and designs in 1911 came into the picture. Then in trademarks came into picture in 1940 and then in 1999. But at this particular time, we can see some cows outside, like in the other part of India, where they used to They used to imprint on cow, stating that this cow belongs to them. So these were the various practice like which were there in the ancient India and in the multiple other parts. Then we had post-independence welfare approach was there. Designs came into picture, then geographical indications, and then TRIPS and WTO. These are the various treaties or standards which we currently follow as a part into WPO. So what is intellectual property coming into the picture? So definition of intellectual property is creation of minds, including inventions, literary, artistic works, symbols, names, images, used in common. What is the purpose of this intellectual property laws or why we have such laws in the picture? So it provides exclusive right to the creators and the innovators and the ideas to a particular person. Besides this, what are the characteristics of intellectual property rights? Characters are it is intangible, it is territorial. So our IP is protected at certain part, but certain part of IP is not protected. Because if, for example, we in the old time we had an example of Starbucks, where Starbucks name and Sardar Bucks name this was quietly used at either of the part. Time bond, we have exclusive rights. There are multiple exclusive rights which are there, which need to be seen that which we get usually while registering this IPs. So international framework coming into picture. Internationally, we have two frameworks: WIPO, World Intellectual Property Organization, and TRIPS agreement. So now getting to the website, I'll just take you to the website and show you that what all courses you can do with World Intellectual Property Organization and some other parts. So this is the actual WIPO website where we can see multiple things as a part, how WIPO works, what is the body doing, how you can partner over here, how what about WIPO, what a WIPO does, what is what are the member states of WIPO, everything particularly related to IPR is stated over here. And they are also having a portal where WIPO, even we can study or partner with WIPO in this part, find and explore, protects and manages, understand and learn. You can also learn these things about patents, trademarks. They have also academy. They have also academy, that is WIPO Academy. You can do some courses over here. Even I have done some courses over here, and those courses are quite interesting courses which you can do as a part and which are for free as a part. I will just show you some courses which you can do as a part and which will help to boost your CV to get into IP firms as a part. So So these are some courses which you can see and skill-based courses which you can do under the IP program or IP league as a part. So now let's move further and so WIPO is there, TRIPS agreement is there. What are the trade-related intellectual property rights which you have and which have been followed from a long particular period of time? Now let us not let's start with the major part of intellectual property which we are about. So what are the types of intellectual property which we see in this particular scenario is patents, copyrights, trademarks, trade secrets, industrial design, and geographical indications. These are the major type of things which we usually see in the intellectual property rights. Now coming towards the major part, that is copyright. In copyright, copyright is a form of intellectual property right that protects original creator, the works. What works are usually protected under copyright law? That is literary works, artistic works, musical work, dramatic work, computer software and programs, cinematographer films, and sound recording. So you can get your protection. If you create a music, you can get a protection over here. If you write something or you research something or a research paper is drawn out, then you get your protection over here. So these are multiple types of protection which you get here into copyright laws. So in copyright, the works covered under copyright, we have already seen that written content, audiovisual content, digital and online content, creative expression, duration of copyright. So what is the duration of copyright? The duration of copyright is literary artist. The duration for the copyright is for literary, artistic, musical, and dramatic work. It is lifetime plus 60 years. For example, Lata Mangeshkar recently passed away. So she had a lifetime of the author, lifetime of the musician, you can say, plus 60 years. Her work will be protected as a part. Cinematography, films, and sound recordings. These are certain things which are cinematography, films, and sound recording. 60 years from the date of publication. So once the movie is released, then 60 years is the time period till what it is protected. And what are the rights which they have? Usually now we can see that movies after being released, they have been sold to either Netflix, either JioStar, either multiple platforms they have been sold. So these are particular things which we can usually find that how copyright is working and how copyright rights which we are having, and it is there in the. So now this is a small and a quick activity which I want you all guys to participate. So in this activity, you just need to answer whether it is a copyright or it is not a copyright. So this is a small exercise which I want everyone to do as a part. So can I have a quick review from others too? Okay, the first question is a the first question is a printed textbook written by an author protected under copyright? So what do you think? Is a printed text book written by an author protected under copyright? Yes, yes, actually it will get a protection. Is a Bollywood song uploaded on YouTube protected under Copyright Act? Is a Bollywood song on YouTube uploaded? Yes, it will get a protection. Are a student are a student handwritten class notes protected under copyright? So what do you think, the notes which you write can be protected as a part? So there, यहाँ पे हमारे पास तीन ऑप्शन है usually: copyright, not copyright, and depends whether it is copyright or not. So your the answer is depends. For coming to the fourth part, is a meme created using a movie still protected under copyright? So what about the fourth question? Uh, Actually, it is protected because if the movie is still in release, then you cannot use certain content because it comes under infringement. Rather coming under copyright, not copyright or depends, it comes under infringement as a part. Is is a YouTube blog created by student protected under copyright? So what do you think? Your YouTube blog created by a student will be protected? Yes, it is protected. Is a mobile application or computer software protected under copyright? So yes, we have seen computer software is covered under the Copyright Act. Is a photograph clicked by a mobile phone protected under Copyright Act? So this is a tricky question. Their answers might be yes also and no also, depends how you use them. So for example, generally the images which we use for the wallpaper of our mobile phones or multiple things. So these are certain images which are clicked and which are protected as a part. If someone has been paid for clicking such pictures as a part. So there is again a question whether it is protected or it is not protected as a part. Eighth question is a content copied from a website and reposted without credit protected under copyright? So this again comes into infringement. And no, just say for example, when you visit to certain pages, you cannot copy or paste things. This is there because they have protected their pages in such a manner where IP leaders, for example, when you visit to IP leaders website, you cannot copy or paste anything. Why is that so? Because there are certain things which are protected and you cannot do certain things at a level. So this was some basics about copyright. Now we will move to the other part, that is patent. What is patent, how patent works, and the basics about patent you will get to know through this particular slides. What is a patent? A patent is an intellectual property right granted to invention but the thing should be new, involves inventive step, capable of industrial application. So सबसे पहले it should be a new thing, it should be a totally new thing, involves an inventive step. So whatever the thing which you have invented should not be, for example, washing machine was invented, and you also again say that you have invented a washing machine, then it is not a new innovation. But in washing machine you have invented a machine which is also having a dryer which dries the clothes, so your there is an innovation. So washing machine is also there, plus you have innovated some new thing in the washing machine, so that is innovation because it involves an inventive step. Capable of industrial application, so it is capable for industrial application. We can sell it, or we can sell that particular design to multiple companies. It gives the inventor exclusive rights to make, sell, or license or reproduce as a part. What can be patented? So what can be actually patented? So new products, new processes, machines or devices, technical inventions, improvements with technical advancement. So this all things can be patented. Some formulas are also patented in this particular thing, which like also we will see right through. Ansh has already said that thing as a part. Example, a new medical device can be patented, a fuel efficient engine can be patented, a new manufacturing process can also be patented. So these are the basics about patent, that multiple things. We cover a large variety of things under patent as a part. What cannot be patented? So under the Patents Act 1970, computer program per se. So this computer program per se, so there are certain things which are not covered under Patent Act, and that is clearly written under section under the this particular part under Patents Act 1970, that these things will not be treated as patents. Business methods, mathematical methods, discovery of natural things. अगर आप कोई natural things में ही आप कोई नई discovery लेके आ रहे हो, तो that thing will not be created as an invention because it was already there. Literary or artistic work will not be covered here because they fall under copyright law. So you cannot overlap two laws at a time. Rights under patent. So what are the rights when what a patent holder have? To make the invention, he is having a right. Use the invention, sell or license it. He can sell it also and license it also. Stop others from using it without permission. So without permission, you cannot use that particular thing. And for the time duration, what is the duration it is protected? It is 20 years. 20 years from the date of filing. It is your application. Whenever the date, whatever is the date of filing of your application, till that 20 years is the time period it is protected. So India is having a thing also known as process patent. So even if even if the thing which you are trying to make is in process, then also you can get a patent in India. But there are multiple countries which don't allow to process patent. But in India, you also have a process patent as a part. So again, there are some questions ahead with you. So I want you all to answer it quickly. So like it will be a session which is including the audience also. Is a new machine used in a factory patentable? I need some answers quickly. New machine used in factory. So like if it is a new invention, then yes, it will be protected. But if just they have bought a new machine to use it, then it will not be covered. So there might be two scenarios in this. Is a new drug formula patentable? New drug formula, yes, it will be patentable. Is computer software code patentable? Third question, is computer software code patentable? Okay, so I would like again, okay. So what cannot be patented? Can you just have a look? Computer program per se, business method, mathematical method, discovery of natural things. Yes, it's a copyright. Perfectly told. Okay. Is mobile application patentable? Is mobile application patentable? I need some answers. Is mobile application patentable? Okay, people are like yet in question. So if it is a new application or certain things are new in that particular application, then they can file for. But there are certain things which are covered under Copyright Act, under Designs Act, under multiple acts, which we'll see other time as a part. So let's move forward. Is a mathematical formula patentable? No, we have already seen in the slides that it cannot be protected. It cannot be patentable. Is a new manufacturing process patentable? New manufacturing process, is it patentable? So yes, it will be patentable. Is literary book patentable? So literary books are not patentable because they are covered under the Copyright Act. And music, is music composition patentable? So no, music compositions are not patentable because they are already covered in the Copyright Act. Is software combined with hardware showing technical showing technical effect patentable? So yeah, when here there is a situation, I will tell you only if software is there, then it will not be patentable because it is covered under Copyright Act. But when software is combined with a hardware, then it is patentable. This is a gist of this, and this is a major part which we can see. So software, if there is only computer software, then it will go under copyright. But when the software is combined to hardware, then it will be covered under the Patents Act. Okay, now moving to the next part, that is Trademarks Act, and a part which you already know, but you don't remember that part as a whole. So now let's move to the part which is trademark. And trademark is a quite interesting part, you can say. Okay, so these are the types of trademark. So what all things we cover: shape, name, M, just M, a symbol which you cover. I am loving it. The slogan is also covered under types of trademark. The color, Cadbury's color, you know, that purple color, that color is also covered under trademark. Perfect. Someone has also written it in the part. Volkswagen is also a symbol and logo, and it is also covered under trademark. So these are the basic types of trademark which you can see in your day-to-day life. So what is a trademark? So trademark is a distinctive sign. It might be a sign, it might be a logo, it might be a word, it might be a phrase, as the phrase I am loving it, McDonald's. Phrase, symbol, or combination used identity, distinguished goods or services of business from another is the major part. Purpose, what is the purpose of creating a trademark? Is protect the brand identity, prevents others from using confusing similar marks, helps consumer identity. So I want you guys to answer, like, for example, me, when I usually travel by trains, I have seen Bisleri का ही duplicate version होगा Bisil Puri, or it might be a Bisleri which is having a double I. So what things you have seen as a part कि ये infringement हो रहा है and no one is looking into it? Yes, audience. Okay, the audience is quite sleepy, I feel. Okay, what can be trademark? So brand names can be trademark. Nike, Apple. Logos can be trademark. Biscuit companies, Monaco. Yes, they certain times face any issues. Lay's also face issues sometimes because there are some similar brands which come up in the picture, right? Brand names, logos में McDonald's with a golden arches has been protected. Slogans or taglines, can you tell me some taglines which are like quite famous? जैसे McDonald's के लिए है I am loving it. What taglines do you know, like, which are quite famous and which remembers, which just give you, just do it, Nike? Yes, more. Like, I feel now we have 74 participants, so now we need a more interactive. Amul दूध पीता है India. Perfect. A good example. Take a break. Take Kit Kat. Through. Have a break. Have a Kit Kat. Take a break. Wala, I have heard. Okay. So these are the basic things which we usually see.
Sir, Red Bull gives you wings.
Yes, perfect. Red Bull gives you wings. Sayyid Mohammed already knows how you can get a wings. Okay. Because because better matter. Belgium waffle is also having a quite famous jingle, you can say. Apple think different, perfect. So these are certain jingles which are protected by them, and also sounds or jingles. जैसे Airtel का जो tune है, you guys already while telling that eat 5 star, do nothing. Okay, this is also there. Tata Namak आज कुछ तूफानी करते हैं. Perfect, thumbs up. A good example, like we can see multiple examples as a part. Sounds and jingles. तो जैसे ही आजकल कोई भी फोन बचता है, you already know that this is the tune of iPhone. How do you know that कि ये iPhone का ही ट्यून है? Nokia का ट्यून. Perfect, a good, very good example you can say. And also we can see like Apple का फोन कैसे भी बज रहा है तो हमें पता चल जाता है कि this is a Apple phone which we can see because this tune we remember. And Airtel के फोन में पहले कॉलर ट्यून एक फिक्स होती थी. Whenever you call, that particular tune used to be there. So in some cases it is also protected as a part and no one can use that tune without your permission, you can say. Mountain Dew. Perfect. This is again a good example, you can say. L'Oreal because you worth it. Perfect. Rights under trademark. So what rights do you have under trademark? Is someone using your trademark? You have exclusive right to use the mark good and services. You can prevent your mark. Duration for the time limit 10 years. Renew after 10 years you need to renovate your trademarks, whatever you have done. But here also there is a thing like if there is an infringement, how many of you go to a part and you say that I need a Xerox copy? How many of you go to the other part and you usually say that I need a Xerox copy or Xerox is a part? Mm, mm. Am I audible? Okay. Okay. So like visiting to Xerox, visiting to the photocopy center and asking for Xerox. You know, Xerox is a famous company and you cannot use the famous word Xerox as a part. And like Xerox has also filed some infringement cases, like people using their term Xerox. Rather, it is a term that is photocopy. And like photo, you cannot use deceptively similar goods also. For example, you cannot use the same name for some other brand. For example, someone asking you a Cadbury silk and you providing him a soap named Cadbury silk. So is that possible that someone will give you a soap and you will accept it as a part? So no, these are certain examples which are like totally distinct, which we see in the market. So IP in everyday brands. So how, what brand things you are having in your day-to-day life, how many IPs are there? Now I will just show it to you. So in just a Parle-G biscuit wrapper, there is a word mark. Brand name Parle-G is the first trademark. Word mark Parle-G styled design is the word mark. Device mark Parle-G doll is the device mark. Trade dress. What is trade dress? Trade dress is the packaging. कि what packaging you are using it, that distinctive packaging slogans, this all are covered under trademark and these are different. अब यहाँ पे पार्ले जी के अंडर कॉपीराइट किन किन चीजों का है? तो कॉपीराइट ऑफ द आर्टवर्क, copyright of the advertising, copyright of advertising, creatives which are created. There are also certain things which we see, artworks, designs are also seen कि वो जो design है, color है, and this all things are like under the trademark and some under the copyright. So under a normal biscuit, you are having so much of IP in you. Okay, just like moving to the next slide. I think there is. The slide is not visible, I feel.
So now it is not, but before this, it was visible. I think you should try presenting it again.
I hope now the slide is visible.
Yes, yes, it is.
Okay. So Springles, a famous brand, and we know there is a device mark, trademark, word mark, chip shape. तो यहाँ पे चिप का भी हम डिजाइन रजिस्ट्रेशन प्लस पेटेंट भी होता है अब दिस इज नॉट जस्ट लिमिटेड टू दिस पर्टिकुलर पार्ट नाउ वी कमिंग अप विथ ट्रेड ड्रेस ट्रेडमार्क डिस्टिंक्टिवनेस सिलेंड्रिकल ट्यूब जो है दैट आल्सो पैकिंग एंड आर्ट लेआउट इसमें भी कॉपीराइट है प्लस ट्रेड ड्रेस है सो लाइक इन जस्ट अ नॉर्मल एक छोटा सा डब्बा है वो स्प्रिंगल्स का इतनी सारी चीजें हम उसमें कवर कर रहे हैं कॉपीराइट है ट्रेडमार्क है डिजाइन्स है पेटेंट्स है मल्टीपल थिंग्स एट लार्ज वी आर कवरिंग so you know when just building a brand we are not just building a small thing we just need to see at a high scenario and like every other thing which can be duplicated by some other person. So now coming up to a thing which is geographical indication, a very slight thing but a very interesting thing you can say. और geographical indication में काफी सारे आंसर्स आप मुझे दे पाओगे and I don't have to ask you. Geographical indication, what is geographical indication? So particularly अभी तक हमने जितनी भी सारी चीजें देखी वो geographical perfectly हमें examples आना already शुरू हो गए perfectly अभी तक हमने जो भी चीजें देखी एक individual protection ले सकता है उन चीजों का but while coming to geographical indication individual cannot take a protection your group of people do take a protection or group of people belonging to the same category same culture same area can take the protection over here. Pashmini shawls, okay. A geographical indication is a sign used by products GI लिखा हुआ होता है that it is a GI product. Qualities, reputation, characteristics from a particular purpose क्या है तो regional product की identity, famous local product names, supports local community and traditional knowledge की what a tradition is and what tradition are we following in the current scenario as a part and what all further things we can see. For some famous example, we have already started getting examples, but I will specify you some examples and then we will go through your examples which are there. Darjeeling tea, Kanchipuram silk. Someone is asking for feedback form. Like you have to wait for another half hour for the feedback form. Kanchipuram silk, Alfonso mango, Petha from Agra. So these are some common examples. Now we will hear some examples from your side. Like I want, can you unmute them all so like they can speak?
Yes, sir, they are unmuted. Guys,
Unmuted.
if you
Okay.
want to
Now I
speak,
want people to speak. In GI they can speak, I feel.
please turn on your mics. Yes.
Yes, Ansh, you can directly speak, not an issue.
Sir, GI is basically a product that derives its origin. That
Okay.
derives its origin. That
Now,
specifically that it defines the thing which comes from the origin.
yes, perfect. So can we get some examples from the audience? Like we are having an audience of 75. So like some examples. Ansh, yes, you can speak directly.
Yes, sir.
Sir,
Like for
tea from
example,
Assam,
Odisha's
sir.
Rasgulla, there was a conflict between Kolkata, West Bengal, and Odisha that who owns the Rasgulla's culture, and
Actually,
Odisha got the
still,
GI tag for Rasgulla.
yes, there is the same for the mango also, Alfonso mangoes and some other mangoes which are there. So multiple things
Yes,
and
sir.
conflicts are usually there, which we see in a local part, but the protection is received by both the communities as a part. Because, for example, did you saw the latest case of Kolhapuri chappals and Prada? Is anyone aware about this cases, Kolhapuri chappal and Prada?
Yes, so they did not consider the GI tags of India and did not give credit at all to the local artists.
But ultimately, you
And
know, they
they
started
have used it.
talking. Just a second. Okay, so legal protection, talking about the legal protection, and like we just had this case of Prada and Kolhapuri chappals. The major thing in Kolhapuri chappals and Prada was they also had a community failure. There is a whole community of Kolhapuri chappals, and there are people belonging to particular area. I had a conference held at my place, so someone who handled this case was there with us. So he just told me that Kolhapuri chappals now they have like made an agreement with Prada as a company. Some community groups have made an agreement. So now their chappals which used to be sold in 1,000, 2,000, now they are being sold at 5,000 and 8,000, and they are earning huge amount of money in the market, which is there again because of the help of Prada. And now Kolhapur is supplying them chappals as a part. So like you never know that you will be famous in a page and then your GI is already gone. Registration provides an exclusive rights. You get a legal protection over them. Over here, you get a protection for 10 years, but it is renewable. You need to renew your license as a part. So I will take you to a video which is there in the website of Wipro. It is a very good video. I hope the audio will not be audible, but you can see the lines which are. Is it audible?
I think, sir, from where you are presenting, you can turn on the audio section as well.
Actually, the audio section is already on over.
Okay, okay.
No issues. The video is having some subtitles with it, so you can see that subtitles. It is a quite interesting video of just 2 minutes. We will see that video. So this was a small quick video for you guys that how geographical indication is there and how GI is protected as a part. So now let's move forward to the Designs Act. What is Industrial Designs Act 2000 and how industrial design usually works in the picture? A design refers to an aesthetic or visual features of a product including shape, pattern, configuration, ornamentation. It must be new or original, not purely functional. So it should be a new design and should be an original design. Purpose of the Design Act: to protect the visual appearance, creativity, and the industrial design and some unique designs which are there. So what all are usually covered under this? Furniture designs, fashion garments, jewelry designs, packaging and labeling, product shapes. So have you ever seen, like, have you ever been to some design which is a registered design? For example, Sabyasachi ke jo lehenge hote hain, या फिर some other parts which are like Zara product which are quite famous through their particular brand. They have their special designs which are registered under designs as a part. Specific building structure, specific design structure, this all are their rights under the act. You can make it, you can sell it, you can distribute it, and you can distribute it through license also. So what is the duration? Initial 10 years from registration. It is renewable in every 5 years term. Maximum protection which can be provided is 15 years. The design is outdated design and people can copy it. So these are some small examples of designs. Graphic image displayed around the vehicle design, registration number, station building, commercial building, bookstore interior, office interior. Can you guys give me some example of designs which are protected designs? Any example for designs which are like protected designs and no one can use that particular design? EKUE print, more like detailed, can you see? Shape of PF Coca-Cola. Yes, the shape is covered over here in a part and also in the trademark as a part. So यहाँ पे एक नॉर्मल चीज आपको सोचना है कि किसी भी बिल्डिंग का स्ट्रक्चर, आर्किटेक्चरल स्ट्रक्चर या फिर कार डिजाइन, यस दिस डिजाइंस आर आल्सो कवर्ड ओवर हियर, कि आपने जो डिजाइन बनाया है, हाउ दैट डिजाइन इज एंड हाउ दैट डिजाइन इज वर्किंग इन द पिक्चर एज अ पार्ट. So coming to the next slide. Now I want to take you to different websites which are there. So there are certain websites which we need to see and which are like quite good websites and which are government authenticated websites. So when you get into it, these websites are certain websites which are very important for you to visit. This is the website of, just excuse me for a while. Okay, there is some network issue my side which I have recently solved. Okay, so this is the major website which is a very crucial website for you filing patents or filing any of the particular part of intellectual property rights. Everything is done through here. Even recently I met the controller of patents who visited our institution as a part. I contacted him through this website. So coming to this websites, we have multiple things in the website which we have to see. Now getting into patents, about patents, history of patents, vision, administration, publication. I want to take you to cost list, the cause list. So these are the daily board hearing matters which you can see. Let's say for example, there are some matters which are scheduled on 21/2006. What is the date today? What is the date today? Audience, we
Sir,
need some
20th
call from
January.
20th, and we can see that these are some hearings which are 20th, which are scheduled on 20th. See 20th 1 2026, 21, 21, 21. So these are various hearings. Now how we can get into this hearings? For example, this is a Apple related case. So once we are going, this is the thing, we view it. So ये यहाँ पे आ गया हमारे पास टाइम, तब हमें मीटिंग ज्वाइन करनी है. फॉर एग्जांपल मीटिंग 21 को वी हैव टू ज्वाइन ऑन 1 PM. 1 PM is the time to join the meeting. For 30 minutes is the time period which is given. So any one of us can join this meeting and see what is happening in the matter. So these matters are quite open matters, and like sometimes you can attend this matter with the permission of the controller. So usually they admit you in certain matters, and these are kept in open. So like you visiting to this website, you get an idea of how things are usually working as a part. See, since claim 16 does not provide new inventive step, future. See, this is there are some reality which are there. Since claim 16 does not provide any new inventive feature beyond the base claim, it should be deleted. So these are some normal things which are there, like which we can see in the website. So going through the website is a very crucial thing, that you go through the website and you see this multiplicity. So it is not just limited to patent, also you can see certain rules. Trademark also, you can find related sections over here. Quick information, hearing board, you can see directly see TLA hearing board. See what is hearing board, what is the registration, copyright, NOC, dynamic TLA. These are some major part which we usually go in. General guidelines for geographical indications, copyright, and these are some other parts which we have to see. So this website also posts internship opportunity. So you can also see some internship opportunities which are usually posted over here. See, we are hiring. Recently, I met him. He also told me that he is currently open to the fourth year and fifth year student for getting into it. Like online internships are there and offline internships are also there, which you can like usually join these programs as a part. So like application end date is 12/1/2026. So there keeps on coming multiple through the website. You can apply to it, and like there are chances that you get selected into it, and like you can get into an internship which is lasting for 3 months, 2 months as a part. Okay, now moving ahead as a part. So some famous case study which we are about to see. The first one is Zara versus House of Zena. This was a trademark dispute where Zara and Zena sounds comparatively similar, and the Zara found it out that though they are not selling some related goods to our part of things, but though it creates a confusion, and this this brand should not be allowed to use the term Zana. Netflix versus YouTube. So there are things which like आज अगर आप देखो तो क्या आपके पास मूवी सेकंड डे पे ही आ जाती है मूवी रिलीज होने के? People can answer this. Like we have tech pro people over here. So like what do you think? We have the movie on the second day itself. Telegram is there. बीच में बंद हुआ था and फिर से अब चालू हो गया. Now we can use Telegram as a part which is like very easy to use, and you get the movie on the second day itself. So these are certain things which is there. Infringement is yet there, but still things are there on the part and there on the line as a part. But there is no protection yet. Amazon वर्सेस बोवेल पोलो क्लब का ये केस था. रिलायंस इंडस्ट्री का ऑपरेशन सिंदूर के टाइम का, दिस वाज द फेमस केस where Operation Sindoor was trademarked by them, and at the other part they backed it out. That was a different scenario which we saw. Now there is a small activity, like we have come to an end. I just want you to know that इसमें से सिर्फ आपको चूज करना है कि कौन से टाइप ऑफ इंटेलेक्चुअल प्रॉपर्टी आपको वो पिक्चर देख के लगता है कि what kind of intellectual property that is. So there it might be a patent, it might be a copyright, it might be a trade secret, it might be a trademark. You just need to find it out what kind of picture it is. Okay. Now just check this, like what kind of intellectual property it is. Okay, quick answers. I need some answers from the audience now. Design Act. Okay. It can be patent also, I feel. So यहाँ पे दो चीजें हो सकती है. It might be covered under design or it might be covered under patent also. So there is a dual combo कि अगर patent, if it is a new thing then it can be a patent, or if new structure is drawn then it can be a design. तो मैंने आपको बताया बहुत सारी चीजें एक साथ आती है. ट्रेडमार्क, कॉपीराइट, पेटेंट भी एक चीज में आता है. तो यहाँ पे हमारा पेटेंट भी आ सकता है. It can be a design also. Both the things can be there. This YouTube, Mercedes, Instagram, Google, McDonald's, Coca-Cola, Microsoft, ट्रेडमार्क. चलो इतना क्लियर हमारे ऑडियंस को पता है कि ये ट्रेडमार्क है. और दिस okay, copyright. We can see a lot of people writing copyright as a part. What about this? What is this? Perfect. This is a trade secret and not patent because KFC के एक chicken leg में there is no patent as such, but there is a trade secret that how do we prepare. For example, you know, recently there was a case कि Starbucks का जो usually formula है, तो फिर यहाँ पे कैसे होता है, जो फॉर्मूला है इट इज लिटरली अ ट्रेड सीक्रेट, बट employee was working with the Starbucks for a long time, he was fired, so he published all the formulas as a part. So there are some times issues which these companies usually face as a part. What is this? Yes, for Coca-Cola too, it is a trade secret. It is a GI, geographical indication, which we can usually see, GI tag. Importance of IPR in the modern economy. So what is the importance? So we can easily distinguish things. Innovation करता है, innovation को growth देता है, because I know if I prepare something, innovation is protected innovation. Encourage investment, research और development. आप particular चीज में और नई research करने की कोशिश करोगे. International trade and economic stability. आपको FDI मिलेगा, फॉरेन से डायरेक्ट इन्वेस्टमेंट्स भी मिलते हैं आपको. जनरेट्स एम्प्लॉयमेंट एंड इकोनॉमिक एक्टिविटी. प्रोटेक्ट्स कंज्यूमर्स इंटरेस्ट, कि कंज्यूमर का भी इंटरेस्ट इज प्रोटेक्टेड. अब व्हाट आर द चैलेंजेस? तो एआई इज अ ह्यूज चैलेंज, बिकॉज आज के टाइम पे व्हेन वी टॉक टू एआई, यूजुअली इफ वी टेल हिम टू प्रोड्यूस अ रैप सॉन्ग एंड गिव इट टू अस, वो तुरंत हमें रैप सॉन्ग बना के दे देता है. देयर आर मल्टीपल थिंग्स व्हिच एआई कैन डू एंड व्हिच इज रिप्लेसिंग द ह्यूमन force as a part. Cross-border IP issues, like my IP is only protected in Mumbai, but only protected in India. What about the other parts of the country? For example, Starbucks is protected in the country which is registered under WTO. But what about the other parts? जैसे अगर for example पाकिस्तान में Starbucks register नहीं है, तो वहां पे तो कोई भी Starbucks open करके यूज कर सकता है. You will never know that they are actually using that particular things as a part. Cultural and traditional knowledge protection, data privacy, and trade secret. These are the big issues which we see. Now I want to share that actually the major part of this meeting was to share you the opportunities which we see. So what are the opportunities in this particular field? So you can be a IPR attorney, you can be a patent agent. There are certain exams lined up with the patent agent. You can be a patent agent. You can be a trademark attorney. You can be a copyright consultant. You can be a portfolio manager. You can be a specialist in IPR for some firms. If they are launching some new things, they will first come to you before launching that, what all requirements we need to do and what all protections which we need to take. There is a patent analyst, researcher, academicians, specialist in government, right manager, IP paralegal भी बन सकते हो आप, IP valuation expert बन सकते हो, ट्रेडमार्क एग्जामिनर बन सकते हो, पेटेंट इंजीनियर बन सकते हो, IP licensing manager बन सकते हो, IP journalist या IP blogger बन सकते हो. Now there are some these are some job opportunities which are posted. So these are some job opportunities which are posted, and like you can usually visit, and these are some ongoing job opportunities. You can see examiner of trademark controller, trainee, research associate, IIT Madras is needing. So these are multiple job opportunities which we usually see are there in the market. Now, I also wanted you to see this part. That is, these are innovations by Indians, and these are 10 huge things which are there. The first one is sewage pipe. So sewage pipe by Perla Mansi Reddy. She has created a sewage pipe This is Perla Mansi Reddy, a civil engineer graduate from Telangana, innovated the O-Pods, a low-cost housing solution built using large sewage pipes. So you can see this, a large sewage pipe is there, and you can usually reside in it, or you can stay in it for a time. Multi-harvester, so at a time you can harvest multiple things. Now this is a cubic bed AC which was invented. Now this we can see is Muhammad Sadiullah built an amphibious bicycle that helps him cross the swollen river to help. I don't know what the issue is with it. Gives a lot of ads. Mitti Cool. This was quite famous. It is IIT model, you can say, Mitti Cool. Jaipur Foot. Devendra Raj Mehta created a low-cost limb. Dr. Vishwas Rao created a voice processor. Bullet Shanti. Mansukh Jagani turned a bike into a multi-utility model to plow or replace bullocks as a part. Spandan. Rajat Jain built a low-cost matchbox, seized portable ECG device. Then solar rickshaw home, auto rickshaw, which which Arun built in a time. So this is some inventions which were built from up there. Now, currently seeing the government scenario or government perspective, government wants you to innovate things, wants you to do your own business, and don't want you to work with a company or slog from 9 to 6 as a part. Rather, government wants you to start up with a new business. You come up with a new innovation, get the innovation protected and on through that. Rather, you just sitting in an IP office or you just sitting anywhere from 9 to 6. That is not the major target of funding. Now, you being in the college years, I would like to show you this video, which is there. They are major startups by friends. So, like, you can choose a good friend which can help you to build some startups. I will just restart it. Okay. Startup found by best friends. Zepto, Team 11, Snappy, Physics Palla, Flipkart, Zomato. So these are certain things which we usually see are created by friends, but they are quite famous, and like you also some can have some good friends, and like you can create something in future. And I feel the Lawscape, which is there in the current session, can also build something which is huge like this in the future time course. So like some Q&A, like some questions from your side will be highly appreciable.
सर आई हैव सम क्वेश्चंस
Okay.
सर मेरा क्वेश्चन ये है कि जैसे कि सर हम लोगों को कोई भी कॉपीराइट या जब हम लोग कुछ अपना लिखते हैं या कोई इन्वेंशन करते हैं तो हमें उसको रजिस्टर भी करवाना पड़ता है पहले कॉपीराइट और पेटेंट की सुरक्षा पाने के लिए सर अगर मेरे रजिस्ट्रेशन से पहले किसी ने उसको कॉपी कर लिया तो क्या मैं जा सकता हूँ कोर्ट इस केस में
आप जा सकते हो. देयर आर सर्टेन टाइम्स. इसमें एक सिनेरियो ऐसा भी है कि अगर फॉर एग्जांपल मैं रजिस्टर्ड नहीं हूँ और स्टिल मेरी चीजें फेमस है मार्केट में,
यस
so
सर
still I can go to the court and I can get protection. That is under the law and that is under the Bar Act also. There are certain sections which say if you are famous in this particular thing, but still you don't have any protection of that name, so still you will get protection. Passing off करके concept होता है, उसमें आप कवर
मतलब सर ये तभी हो सकता है जब हम फेमस हो मार्केट में मतलब कि
हाँ राइट. बट अल्टीमेटली जब आप रजिस्टर नहीं कर पाते और आपसे पहले कोई रजिस्टर करता है तो ये लॉ यूजुअली उनको सुरक्षा पहले देगा आपसे.
अच्छा सर मतलब मैंने पहले लिखा उसने बाद में लिखा उसने पहले मुझसे रजिस्टर करवा दिया तो उसको सुरक्षा मिलेगी इसका मतलब कि
Yes, it is there in the part. So like you have to be, जैसे हमारे पास पेटेंट में कैसे चीजें होती है, आप कोई नई चीज कर रहे हो तो आप प्रोसेस का पेटेंट ले लो, तो आप पहले ही खुद को प्रोटेक्ट कर रहे हो. तो ये फैसिलिटीज है हमारे पास, इससे आगे फैसिलिटीज नहीं है हमारे पास, बिकॉज
और
द
सर
लॉ.
मान लीजिए, सर मेरा क्वेश्चन, अगर किसी, मान लीजिए मैंने कोई आइडिया बस निकाला था लेकिन उस आइडिया को कंप्लीट किसी और ने किया, तो क्या ऐसे में मेरे पास कोई प्रोटेक्शन होती है?
ये इस चीज
आइडिया
के ऊपर भी डिपेंडेंट है कि आपने उससे अगर हेल्प ली है, तो यू माइट हैव क्रिएटेड सम कॉन्ट्रैक्ट और सम कॉन्ट्रैक्चुअल ऑब्लिगेशंस एज अ पार्ट. इफ इट इज अंडर दैट, देन यू कैन हैव अ म्यूचुअल कंसिडरेशन दैट हाउ यू आर गोइंग अहेड विद दैट पार्ट.
ओके सर. सर एक और क्वेश्चन माइंड में था. ट्रेडमार्क पढ़ाते हुए आपने बोला था कि वर्ड भी इस ट्रेडमार्क की कैटेगरीज में आते हैं, राइट सर? वर्ड सर, यस सर, वर्ड.
अब वर्ड मार्क जैसे होता है ना, पर्टिकुलर वर्ड हम लोगों ने किया
ये-
हुआ है मार्क, जैसे फॉर
नहीं सर.
एग्जाम्पल
कुछ दिन पहले केस मैंने पढ़ा था जिसमें फोन पे ने भारत पे पर केस किया था कि पे रिमार्क नहीं होना चाहिए भारत पे में, वो ट्रेडमार्क का उल्लंघन है, तो कोर्ट ने रिजेक्ट कर दिया था फोन पे की इस पिटीशन
अब
को.
यहाँ पे कुछ चीजें होती है. वेल नोन मार्क्स, वेल नोन मार्क्स एक अलग कैटेगरी और एक नॉर्मल चीज है. जैसे फॉर एग्जाम्पल यू कैन नॉट ट्रेडमार्क शुगर, सिर्फ शुगर आप ट्रेडमार्क नहीं कर सकते, पर उसके आगे पीछे अगर कुछ लिखा होगा एंड दैट इज इन कंटिन्यूएशन विद शुगर, देन यू कैन प्रोटेक्ट इट. बट यू कैन नॉट जस्ट प्रोटेक्ट शुगर बिकॉज इट इज अ कॉमन कंपोनेंट विच एवरीवन नोस. सो एक कॉमन
Oh.
चीज को आप कभी ट्रेडमार्क नहीं करवा सकते.
ओके सर. और सर क्या मैथमेटिकल फॉर्मूला पेटेंट नहीं हो सकता, लेकिन क्या कॉपीराइट हो सकता है मैथमेटिकल
हाँ.
फॉर्मूला?
मैथमेटिकल फॉर्मूला आप पेटेंटों से नहीं करवा सकते हो, बट कॉपीराइट में यू कैन ट्राई इट, बिकॉज टिल नाउ आई हैव नॉट इवन सीन दिस थिंग्स कि मैथमेटिकल जो फॉर्मूलाज है वो कॉपीराइट के अंडर भी प्रोटेक्ट हो रहे हैं, बिकॉज आई हैव नेवर
ओके सर.
फाउंड सच रजिस्ट्रेशन एज अ पार्ट,
ओके
बिकॉज
सर.
आज के टाइम पे मैथ्स में लोगों को इंटरेस्ट ही कहाँ होता है.
यस सर. ओके, थैंक यू सर.
Yes. Any other questions from the other people? Could we get PPT, PDF? Like PPT, I have already sent it to them, so they will send it to you. Ayushi, yes.
Hello, sir. I have a question.
Yes.
In case there is a new business a person needs to start, and the product is handcrafted things. So
Okay.
will it come under artistic stuff? So there
What
should be
kind
a
of product he is like preparing? What kind of product is that?
craft product. Let's say bookmarks and stuff like that. Bookmarks, journals. So
Okay.
will it be covered under copyright, or the brand name would be covered under trademark, or both?
Now over here, as I just show you the Parle biscuit packet. So have you
Yes.
seen that there were 3 to 4 things which were covered in a small thing?
Yes, sir.
Getting into Sprinkles also, we got 4 registrations.
Mhm.
So seeing that particular artistic product, we can say it might be covered under copyright also. You need to take some permission from copyright also. You need to get it registered under trademarks also. Or for
Okay.
example, if your design is unique, you can also get it registered under Designs Act. So the more the product is like there and more the protection you take, you are like protected as a part. Majorly आप सारी जगह से protect हो जाओगे.
Okay, sir. Thank you so much.
What about others? Any questions?
सर एक लास्ट क्वेश्चन मेरे माइंड में आ रहा है.
हाँ.
मान लीजिए सर कि किसी दिन मैं अपने दोस्त से ऐसे ही बात कर रहा हूँ, मैंने उसको कोई अपना ऐसा आइडिया बता दिया, और जैसे मुझे ये चीज इन्वेंट करनी है और ये ऐसे ऐसे इन्वेंट हो सकती है, मेरे दोस्त ने जाकर उसको इन्वेंट कर दिया, तो क्या मैं कोर्ट में जाकर कह सकता हूँ कि उसने मेरा आइडिया कॉपी कर लिया है?
अब ये आपके पास प्रूफ करने के लिए होना चाहिए. यूजुअली
Okay.
ऐसे जो आपने केस बताया वो ऑलरेडी केस आ चुके हैं और हमारे पास भी आते हैं, बट यहाँ
अच्छा.
पे दे हैव अ क्लियर सिनेरियो दैट द वन हु रजिस्टर्स फर्स्ट is having that thing with him and he will own the major rights. So
सर एक बार दोबारा बताइएगा ये चीज.
जैसे जो पहले रजिस्टर कर रहा है उसी को हम
हाँ.
प्रोटेक्शन देते हैं. भले ही वो आइडिया पूरा आपका रहे बट किसी और ने रजिस्टर कर दिया, स्टिल यू लूज. बट इन कोर्ट इफ यू फॉर एग्जांपल आप हमेशा ऑपोजिशन के लिए जाओगे इस चीज में, तो उसका कभी भी वो एक सक्सेसफुल रजिस्ट्रेशन नहीं होगा. बिकॉज अगर आपकी कोई चीज ऑपोजिशन में अटकी हुई है तो उसके लिए आपको बुलाया जाएगा फॉर दैट पर्टिकुलर हियरिंग, और आप जब एक ऑफिसर के सामने बैठे हो तो तब आपके पास एक ऐसा पूरा प्रूफ होना चाहिए कि आपने उसे बताया था एंड ही हैज कॉपीड योर पर्टिकुलर थिंग, देन द थिंग्स विल बी हेल्पिंग यू, अदरवाइज द थिंग्स वोंट बी एबल टू हेल्प यू।
ओके सर, मतलब सर्कमस्टेंसेस और फैक्ट्स डिपेंड करते हैं इस ऐसे मामलों में।
यस यस, वो उसके लिए आपको
ओके सर।
टाइम लिमिट बहुत सारी चीजें दी जाती है ऐसे ही।
ओके सर।
फॉर एग्जाम्पल, फॉर गेटिंग अ ट्रेडमार्क रजिस्टर्ड माइट टेक ईयर्स ऑल्सो, 1 2 3 years। इसके लिए बोला है जिस दिन से आपको बोला है कि ये एप्लीकेबल है उस दिन से लेके 10 साल तक का टाइम। ऐसे नहीं कि आज ही बोला और आज का टाइम आपसे क्लोज करवा रहे हैं, बिकॉज लोगों को वो रजिस्टर करते करते भी इट टेक्स 2 years 3 years, और विद इन 6 months या 1 year में भी रजिस्टर हो सकता है इफ देयर इज
और
नो।
उसके 10 साल सर, 10 ही साल तक मतलब मिलेगी कॉपीराइट में सुरक्षा आपको?
हाँ।
ओके सर।
Some other question from Mr. Ravindra.
Sir, my question is that if someone registered under the design protection or trade protection, but he forgot to register in other section, but some other persons copying same thing. So, but this person is registered under the trademark or in one section, right? Whether he will have legal advantage over them to win?
See, if you are registered in any of the parts, then you already have your rights with you. So no one
Okay.
else can register in any other part. Because जब हम register करते हैं तो हम उसमें एक विंडो ओपन रखते हैं कि ऑब्जेक्शन के लिए there is a window which is open. ये तो हमने अभी बेसिक्स का पार्ट किया। When we get into copy, जैसे फॉर एग्जांपल आपको एक कॉपीराइट बताने में भी it will take like 5 days of time to explain whole copyright के लिए, इतना ह्यूज पर्सपेक्टिव है लॉ का। सो इन दिस जब आपको अपोजिशन आता है तो अपोजिशन ऑल्सो टेक्स अ लॉट ऑफ टाइम, कि अपोजिशन के लिए वो विंडो ओपन है, आप न्यूज़पेपर में पब्लिकेशन देते हो कि दिस एंड दिस थिंग इज गोइंग टू बी देयर एंड मल्टीपल थिंग्स व्हिच आर अबाउट टू सी, सो देयर आर मल्टीपल थिंग्स व्हिच वी सी। और उस ऑपोजिशन पीरियड में अगर ऑपोजिशन आए तो ऑपोजिशन को पहले सॉल्व करना पड़ता है। वंस द ऑपोजिशन इज सॉल्व देन या तो रिजेक्ट होगा या तो एक्सेप्ट होगा, अगर एक्सेप्ट हो गया है देन फिर इट विल गो टू द अदर प्रोसेस। So there is a time limit which is there for every particular process.
Okay, okay, but no, still
You will be
I
secure.
didn't get
If you are registered anywhere, if you are registered, you will be secure.
Okay, because no, see, while registering, we not aware that our design also unique. Just I registered for only trademark, but later
also
I
that is okay.
okay,
Yes.
that's okay, right? Okay.
Okay. Yes. What about others? Any questions or like we will wind up? Any questions? Then we wind up for the day.
Okay.
Internship opportunities. There are many internship opportunities available on the website, IP website. Like majorly, if you visit IP website, copyright ke liye we have a separate website. Copyright, if you specifically go in IP website, there are usually a lot of vacancies which usually come in every quarter because they hire a lot of interns. Yes. Yes, Tuba, you are having any doubt?
Yes, sir. Sir, I have a question. Like, we can think IPR laws are strong enough to protect creators today?
Actually, seeing the current scenario when AI is into the picture, it has become a question. Like, for example, if I write my research paper through AI, but I cannot give AI the tag that I have copied it from ChatGPT and I'm writing this paper, because that protection is not there with me yet as a part. Yes. So like AI, when you come into this and you ask me that is like today the content protected? So आज के time पे when I cannot see much people creating songs or usually doing this thing. So copyright, usually you can say कि अब copyright I feel अगर AI के related हम नए laws के साथ नहीं है, then it will be difficult to get new persons in the picture as a part, you can say. Okay. Ansh, what is your doubt?
Sir, since you have mentioned AI, and since AI is in the field of creative art also, and artists are taking help and assistance from AI, if art is created, suppose ChatGPT or AI or Gemini Nano banana,
Yes, yes.
So who will get the copyright entitlement? The person who have entered the prompt or the persons from whose art AI learned the pattern of making of that art?
Actually, over here, there is an issue which is there. So the first issue which I state usually about this is when coming to the picture, when we talk usually about AI as a part. So EU is already having a AI act with them, but we are not having any AI act with us till now. So like ultimately, for example, पहले जब हम चैट जीपीटी यूज करते थे हम इमेजेस इंसर्ट नहीं कर पाते थे. Then recently the chat GPT has evolved. Now you can put images and you can find out data. You can upload PDFs and then you can get the data out. But ultimately it helps also you. For example, I writing my research work. मैंने जो भी मेरे दिमाग से सोचा है, I get that content, I write that content. और मैं सिर्फ chat GPT को reframe करने बोलता हूँ. So when I go to turn it in and when I put it under plagiarism, it doesn't shows plagiarism, but the issue is it shows AI. कि मैंने वो AI content use किया है 40%. But I cannot give AI you know I cannot put AI under the footnote also because it is not allowed. So ultimately we are yet silent about AI and we don't have such guidelines related to AI, you can say. Okay.
Sir, you mean to say things created with AI won't get copyrights, right?
Yes, I'm like straight away saying this because if AI becomes the author and if AI becomes co-author, we'll lose our business.
Okay. Got it.
Okay, does anyone have any questions, guys?
Yes, sir. I
Okay.
have one more question.
Yes, sir.
सर जैसे अभी बीच में इंस्टाग्राम पे ट्रेंड चल रहा था, एक गिबली आर्ट था जो एनिमे स्टाइल की फ़ोटो क्रिएट्स करते थे. तो जो एक स्टूडियो थी गिबली आर्ट्स, क्या वो क्लेम कर सकते हैं कि ये सिमिलर पैटर्न या सिमिलर आर्ट स्टाइल है जो मेरा है? तो उस पर वो कॉपीराइट क्लेम कर सकते हैं क्या अगर वो फ़ोटो जो जनरेट की गई वो किसी कॉमर्शियल में यूज किया जाए?
They can take this in the other part, but the issue over here is अगर उन्होंने register किया हुआ है, then they can take certain actions against them. But this art being a very common art, like anyone can use it, and online it is free, so they cannot like just take into contempt. But still, they can file a suit against them, and like there are certain times where they can win also the suit.
ओके सर, मतलब ये अगर वो आर्ट स्टाइल जो भी है वो पब्लिक यूज में है तो कोई क्लेम नहीं ले सकता, बट अगर वो रजिस्टर्ड है तब ले सकते हैं.
रजिस्टर है तब वो दे सकता है कि उनका आर्ट आप यूज कैसे करो उनसे बिना परमिशन के. जैसे आई रिसेंटली इंटरव्यूड अ पर्सन हु इज फ्रॉम हैदराबाद एंड ही इज मोर इनटू पेंटिंग्स एज अ पार्ट. सो इन दिस सिचुएशन व्हेन आई टोल्ड हिम कि एआई कमिंग इनटू पिक्चर लाइक योर पेंटिंग विल नो मोर बी इन द मार्केट, तो उसने मुझे रिप्लाई में बोला कि अल्टीमेटली वो मेरे जैसा क्रिएटिविटी कभी भी नहीं कर पाएगा बिकॉज मैं सोच रहा हूँ और मैं मेरे हिसाब से कुछ पेंटिंग्स बना रहा हूँ. आई हैव अ एक्सप्लेनेशन बिहाइंड दैट पेंटिंग, बट दैट एआई विल नेवर हैव अ एक्सप्लेनेशन बिहाइंड दैट पेंटिंग which explanation I am having with it. So he doesn't feel that his business will be affected with AI. Okay.
एंड सर आई हैव वन मोर क्वेश्चन.
Okay. So like we can handle now.
Sir, I have one more question. Can we take copyright claim on the prompt we write? If I have written a full descriptive creative prompt and by that prompt I have created an art, so can I take copyright on that patent also so and no one else can use it?
जैसे फॉर एग्जाम्पल आप बिना बताए अगर कोई चीज कर रहे हो, जैसे आपने नहीं बताया कि आपने वो कॉपीराइट के थ्रू जनरेट किया है, तो अभी तक वो आपका मटेरियल चल ही रहा है. बिकॉज अल्टीमेटली फॉर एग्जाम्पल आई राइटिंग अ रिसर्च पेपर, मैंने उसे भेजा और वो पब्लिश भी हो गया, तो अल्टीमेटली बिना बताए तो वो पब्लिश हो ही रहा है. एंड नो वन इज देयर टू टेल मी दैट दिस इज अ एआई जनरेटेड कंटेंट, यू कैन नॉट यूज इट. नो वन इज देयर टू टेल मी टिल नाउ. अभी तक मुझे वो कोई बताने के लिए है नहीं कि ये एआई कंटेंट है. So it is working in the market.
Okay, sir. Thank you, sir.
What about like I feel we can end this session, Giriraj.
Okay. First of all, it's really great to see a lot of questions at the end of the session. I hope the session was really productive. Thank you so much, sir. That was really an insightful session. I think the way you explained complex legal concepts of IPR made it really easy for all of us to understand. So I would like all of you to give a big round of applause for sir using your emojis. And for the most important part,